The legal questions surrounding Prince Harry and Meghan Markle's marriage. It appears the controversy surrounding Prince Harry and Meghan Markle has entered another turbulent chapter. Following another difficult weekend, reports and commentary have suggested that tensions within the couple's relationship may be attracting renewed attention, including from sections of the British media. Their recent separate appearances in New York have only fueled further speculation, with Harry attending one engagement while Meghan appeared elsewhere. To understand why their marriage continues to generate such intense discussion, we have to go back to May 19, 2018. That day was promoted as the wedding of the century, a multi-million-pound royal spectacle watched by millions around the world. The carriage procession, Meghan's Givenchy wedding gown, the ceremony at St. George's Chapel, and the carefully staged images all appeared to represent a modern chapter in the history of the British monarchy. But beneath the celebration, questions have continued to circulate online and within royal commentary about the legal circumstances surrounding the marriage. Some commentators have gone much further, alleging that the marriage could somehow be legally invalid. These claims have included speculation about constitutional procedures, the role of the Church of England, and alleged inconsistencies concerning information contained in official documents. However, these allegations should be treated as claims and speculation rather than established facts. There is no established evidence that Prince Harry and Meghan Markle's marriage has been legally declared void. One of the central claims concerns the alleged vetting process before Meghan married into the royal family. Historically, relationships involving senior members of the British royal family have been subjected to extensive scrutiny. Backgrounds, personal histories, family connections, and potential security concerns could all become relevant before a marriage was approved. By 2017 and 2018, however, the monarchy was operating in a rapidly changing media environment. Harry and Meghan's relationship developed quickly, and their engagement was presented as part of a more modern and diverse image for the institution. Critics have argued that the palace moved too quickly and that certain aspects of Meghan's background were insufficiently examined. But claims that the palace conducted virtually no vetting remain unsubstantiated. Another issue repeatedly raised by critics involves Meghan's date of birth. Her publicly established date of birth is August 4, 1981. Various internet commentators have nevertheless pointed to supposed discrepancies in school records, registrations, and family accounts in an attempt to argue that she may be older than officially stated. That allegation has circulated for years, but repetition online does not establish that it is true. The legal argument built around the claim is nevertheless dramatic. Under British law, marriage is governed by specific statutory requirements, and information provided during the marriage process is legally significant. Deliberately providing false information on an official document can potentially have serious consequences. But that does not automatically mean that an alleged discrepancy in someone's age would make a marriage void. For a marriage to be declared void from the beginning, the relevant legal requirements would have to be satisfied, and the circumstances would need to be established through the appropriate legal process. A sensational allegation is not, by itself, sufficient to invalidate a marriage. This is also where the Archbishop of Canterbury, Justin Welby, enters the story. Welby officiated at Harry and Meghan's 2018 wedding, making his role particularly significant whenever questions about the ceremony arise. The controversy intensified after Meghan and Harry's 2021 interview with Oprah Winfrey. During that interview, Meghan said that she and Harry had exchanged vows privately 3 days before the public wedding. The statement generated considerable attention because it appeared to suggest that the couple had already been married before the ceremony at Windsor. Archbishop Welby later clarified that the private exchange was not a legally recognized marriage ceremony. He explained that the legal wedding took place on May 19, 2018, and that he signed the marriage certificate. That clarification is important because it directly contradicts the interpretation that the couple had legally married 3 days earlier. The broader controversy therefore rests on two very different things: documented facts surrounding the 2018 ceremony and a series of allegations that have developed through commentary and alternative media. The public record confirms that Harry and Meghan married on May 19, 2018, at St. George's Chapel, Windsor Castle, with Archbishop Justin Welby officiating. The claim that the marriage is legally void because of an alleged false age or defective vetting process, however, has not been established as a legal fact. And while their separate public appearances and continuing media scrutiny may generate speculation about the state of their relationship, appearances alone cannot establish what is happening privately between them. What began in 2018 as one of the world's most celebrated royal weddings has therefore evolved into a continuing subject of fascination, criticism, and speculation. Whether the issue is their relationship, their position within the royal family, or the legal circumstances of their wedding, the distinction between verified evidence and sensational claims remains crucial. For now, the documented position is straightforward. Prince Harry and Meghan Markle remain legally married, and there has been no established legal ruling declaring their marriage void. The legal questions surrounding Prince Harry and Meghan Markle's marriage. Behind the scenes, the controversy surrounding Prince Harry and Meghan Markle's 2018 wedding has continued to fuel speculation. According to the claims presented in this narrative, there is concern within parts of the Church of England that Archbishop of Canterbury Justin Welby could face difficult questions if the ceremony were ever alleged to have contained a serious legal defect. If such reports were ever substantiated, any attempt to review or challenge the marriage would not necessarily be about personal hostility toward Harry or Meghan. Instead, it would be framed as an institutional responsibility. The Church of England has historically played an important role in royal weddings, and questions involving the accuracy of official marriage records could therefore become highly sensitive. The distinction between a royal divorce and a declaration that a marriage was never legally valid would be enormous. Britain has dealt with royal divorces before, particularly during the turbulent years of the 1990s. But declaring that one of the most internationally watched royal weddings of the modern era was legally defective from the beginning would create an entirely different situation. The potential consequences would also be significant. One argument frequently raised by critics concerns Meghan's title, the Duchess of Sussex, which she received when she married Harry. Some commentators have suggested that if the marriage were ever legally declared void, questions could arise over whether a title derived from that marriage could continue. The same applies to discussions surrounding their children, Prince Archie and Princess Lilibet. Their constitutional position and place in the line of succession are governed by specific laws and rules. It would therefore be misleading to assume that a dispute over the parents' marriage would automatically remove them from the succession. Any such determination would require careful consideration of the applicable constitutional and legal framework. Financial matters could also become complicated. A marriage declared void is legally different from a marriage ended through divorce, and the consequences for property, financial arrangements, and other rights can vary considerably depending on the circumstances. For Harry, however, the emotional implications would arguably be even greater. Since marrying Meghan, he has made major changes to his public and private life. He stepped back from his role as a senior working royal, relocated to the United States, and publicly defended his relationship and his decisions. The suggestion that the legal foundation of his marriage might somehow have been defective from the outset would therefore represent an extraordinary reversal of the story surrounding the couple. But there is an essential distinction between a dramatic hypothetical scenario and an established legal fact. There has been no publicly established ruling declaring Harry and Meghan's marriage void. This raises another question. Why has Buckingham Palace not launched a public investigation into the allegations? One possible explanation is the monarchy's long-standing preference for avoiding direct engagement with every controversy. The familiar principle of never complain, never explain has often characterized royal communications. Opening an investigation into the legality of Harry and Meghan's wedding could potentially create even more attention than the original allegations. It could invite scrutiny of the palace's vetting procedures, the Church of England's role, the marriage documentation, and the constitutional implications surrounding the Sussexes. A public admission that the palace had somehow failed to conduct adequate checks or permitted a legally defective ceremony would be extraordinarily damaging. Yet the absence of a public response should not itself be interpreted as proof that the allegations are true. Much of the current controversy stems from claims circulated by commentators and alternative media rather than from a confirmed legal proceeding. The debate nevertheless touches on a broader issue, whether influential individuals should be subject to the same legal standards as everyone else. For ordinary citizens, knowingly providing false information on official documents can have serious consequences. That principle naturally raises questions about whether public figures should receive any different treatment. However, an alleged discrepancy does not automatically establish criminal fraud, nor does it automatically make a marriage void. The precise facts, intent, legal requirements, and evidence would all matter. This is why the role of Archbishop Justin Welby remains central to the narrative. Welby personally officiated at Harry and Meghan's wedding on May 19, 2018. He later clarified an important point concerning Meghan's claim during her Oprah Winfrey interview that she and Harry had exchanged vows privately 3 days before the public ceremony. Welby explained that the private exchange was not the legally recognized marriage. The official wedding took place on May 19, 2018, and the legal marriage documentation was completed in connection with that ceremony. That clarification is significant because it distinguishes a private exchange of vows from a legally recognized marriage. The more dramatic allegation that the official marriage itself was defective because of supposedly inaccurate personal information remains unproven. If, hypothetically, an official government review were ever to discover a material falsehood in a marriage document, the situation could become legally serious. Authorities could investigate the circumstances, lawyers could become involved, and questions could arise regarding the validity or consequences of the documentation. But the mere existence of a disputed claim would not be enough to reach that conclusion. That distinction is particularly important when discussing Meghan Markle. Describing her as an American actress who married into the world's most famous family makes for a compelling media narrative, but it does not establish that she committed fraud or that her marriage is invalid. The central question, therefore, remains hypothetical. What would happen if a legally significant defect were actually proven? If such evidence emerged and the appropriate authorities determined that the marriage failed to meet the legal requirements, the consequences could extend far beyond Harry and Meghan personally. The 2018 ceremony, royal titles, constitutional questions, and public understanding of the modern monarchy could all become subjects of renewed scrutiny. It could become one of the most consequential legal controversies involving the modern British royal family. But as of the present, there is no established legal ruling that Prince Harry and Meghan Markle's marriage is void. The couple remain legally married, and Archbishop Justin Welby has not publicly declared their wedding invalid. What continues to circulate is a narrative built around allegations, disputed interpretations, and hypothetical legal consequences. The story is compelling precisely because it asks a provocative question: was everything surrounding the 2018 wedding handled correctly, or could important details have been overlooked? Until credible evidence or an official legal determination answers that question, the distinction between speculation and fact remains essential. The fairy tale presented to the world in Windsor may have been followed by years of controversy, family conflict, and intense media scrutiny. But whether those later controversies have any bearing on the legal validity of the original marriage is a separate question, one that cannot be settled by rumor alone. The allegations surrounding the vetting and legal validity of Harry and Meghan's marriage. Let us be precise about what is being alleged. The claim goes beyond ordinary tabloid gossip or a social media rumor. It centers on a specific legal theory that Meghan Markle may not have undergone adequate vetting before her engagement to Prince Harry was announced, that important background information may have been overlooked or insufficiently investigated, and that this alleged failure supposedly allowed inaccurate information about her age to appear on official marriage documentation. The most serious version of the allegation goes even further, claiming that such an alleged discrepancy could somehow invalidate the entire marriage under English law. That is a dramatic proposition, and it is important to distinguish the allegation from established fact. There has been no publicly established legal ruling declaring that Meghan falsified her age on the marriage certificate or that Harry and Meghan's marriage is void. Nevertheless, supporters of the theory argue that even seemingly minor inaccuracies can become significant when they appear on an official state document. The British monarchy is not simply a celebrity institution. It operates within a constitutional and legal framework involving the United Kingdom and the wider realms where the monarch serves as head of state. Royal marriages can therefore carry constitutional implications beyond the private relationship of the individuals involved. The legal framework surrounding royal marriage has evolved over centuries. The Marriage Act 1949, the succession to the Crown Act 2013, earlier royal marriage legislation, and the established role of the Church of England all form part of the broader historical context. However, not every royal wedding constitutes an act of state in the simplistic sense sometimes suggested online, and the precise legal consequences of a disputed marriage document would depend on the facts and applicable law. That distinction matters. The marriage of Prince Harry and Meghan Markle took place on May 19, 2018, at St. George's Chapel, Windsor Castle. Archbishop of Canterbury Justin Welby officiated, and the marriage was formally registered. Consequently, any allegation concerning the accuracy of that documentation would be a serious matter if it were ever supported by credible evidence. The central question then becomes the alleged vetting process. Royal engagements historically involved substantial scrutiny. Security considerations, personal history, family background, public activities, financial circumstances, and other potential risks could all be relevant when assessing someone entering the immediate royal family. Harry and Meghan's relationship, however, developed relatively quickly. Their engagement was announced in November 2017 after they had first met in 2016. Their wedding followed approximately 6 months later. That compressed timeline has encouraged critics to argue that the palace may have prioritized the public image of a modernizing monarchy over traditional scrutiny. The couple represented a significant change in the public presentation of the royal family. Meghan was American, biracial, divorced, and an established actress. Her relationship with Harry therefore attracted enormous international attention and was widely presented as evidence of a more modern and inclusive monarchy. But the claim that the palace effectively abandoned its vetting procedures remains unproven. There is also controversy surrounding alleged inconsistencies in Meghan's biography, including claims about her birth date, education, and early professional history. Various online investigators have attempted to assemble these supposed discrepancies from public records, archived material, professional databases, and historical interviews. Their conclusions have been used to argue that Meghan's officially stated biography contains unexplained inconsistencies. Yet the existence of conflicting claims online does not establish that official records are false. Nor does an alleged inconsistency automatically demonstrate that a criminal offense occurred. That is where the argument becomes more complicated. If a genuine material falsehood had been knowingly entered into an official legal document, authorities would need to determine what information was provided, who provided it, whether it was knowingly false, what legal requirement applied, and whether the alleged error had any effect on the validity of the marriage. Those questions cannot be answered simply by comparing different versions of someone's biography. This also explains why the Archbishop of Canterbury remains a prominent figure in the controversy. Justin Welby personally officiated at Harry and Meghan's wedding in May 2018. Years later, his role became part of another controversy following Meghan's interview with Oprah Winfrey. During that interview, Meghan said that she and Harry had exchanged vows privately 3 days before the public ceremony. Welby subsequently clarified that this private exchange was not a legally recognized wedding and that the legal ceremony occurred on May 19, 2018. That clarification placed Welby directly in the middle of an already controversial public narrative. Critics now use his involvement to ask a much broader hypothetical question. What responsibility would an officiating archbishop have if a marriage document were later proven to contain a serious legal defect? The answer would depend on the circumstances. Signing or officiating a document does not automatically make the officiant responsible for every piece of information supplied by the parties. Nor does the presence of an alleged error automatically invalidate the entire ceremony. Nevertheless, if credible evidence ever demonstrated that a material falsehood had deliberately been entered into the official record, the matter could become extremely serious for everyone involved. For the moment, however, that remains hypothetical. There is no publicly established finding that Archbishop Welby knowingly signed a fraudulent marriage certificate. There is also no established finding that Meghan deliberately provided false information about her age. The more dramatic interpretation therefore rests on a chain of assumptions. First, that the palace failed to conduct proper vetting. Second, that the alleged discrepancies in Meghan's biography prove her official age was false. Third, that the information was knowingly entered into the marriage record. And finally, that this alleged falsehood would legally invalidate the marriage. Each step would require evidence. That is why the question of whether the palace looked closely enough at Meghan's background remains more complicated than the dramatic narrative suggests. If the institution genuinely overlooked important information, it could represent a failure of judgment. If evidence ever demonstrated that officials knowingly ignored legally significant information, the implications would obviously be much more serious. But at present, neither conclusion has been established as fact. The 2018 wedding remains a legally recognized event, and Harry and Meghan remain married. Their subsequent departure from royal duties, move to the United States, media projects, interviews, and continuing public controversies have generated years of debate about their relationship with the monarchy. Yet none of those later developments, by themselves, establish that the original marriage was legally defective. The controversy therefore continues to revolve around a provocative but unproven question, were important details overlooked during the preparation for the 2018 wedding, or has an internet-driven theory transformed disputed biographical claims into an allegation of constitutional significance? Until credible evidence or an official legal determination provides an answer, the distinction between documented facts and speculation remains essential. What is certain is that Justin Welby officiated at the May 19, 2018 ceremony. The marriage was formally recorded, and the couple have continued to be recognized as husband and wife. Everything beyond those established facts must be approached with considerably more caution. The custodian of royal marriages, the Archbishop of Canterbury, finds himself in a difficult position. Prolonged silence on questions surrounding the Sussex union is increasingly read by some as tacit acceptance, a stance no holder of the office would welcome. Reports have circulated of growing calls within ecclesiastical circles for a formal annulment process to examine whether every statutory condition for a valid Church of England marriage was satisfied. In this framing, an annulment would not amount to a moral verdict on the personal bond between Prince Harry and Meghan Markle. It would be presented as a technical legal finding that the formal requirements were not fully met, so the Church could not continue to treat the union as having existed in law. The practical consequences imagined by proponents of this view are far-reaching. The title Duchess of Sussex, conferred upon marriage, would simply lapse without any need for divorce proceedings or negotiation, because it rested on the premise of a valid marriage. The public identity and commercial brand built around that royal status would lose its foundational credential. The children's places in the line of succession, Archie and Lilibet, currently ranking after their father, are likewise described in these arguments as dependent on their parents' lawful marriage. A declaration that the marriage was void would, on this reasoning, trigger urgent constitutional questions, drawing in Crown lawyers and the Privy Council and raising wider issues for the monarchy's future arrangements. Commercial contracts, streaming agreements, podcast deals, publishing arrangements, negotiated on the basis of Meghan's status as Duchess of Sussex would also come under scrutiny, with lawyers on both sides of the Atlantic examining whether the altered legal footing affected their validity. For Harry himself, the personal cost is portrayed as especially heavy, having severed military ties, surrendered royal roles, and publicly criticized his family in defense of the marriage. He would face the collapse of the rationale for those sacrifices if the law were later to treat the union as never having existed. These scenarios rest on real legal instruments, the relevant statutes, the marriage register entry, and the signature of the then Archbishop, yet they remain speculative. In historical fact, the couple's legal wedding took place on May 19, 2018 at St. George's Chapel, Windsor. The then Archbishop of Canterbury, Justin Welby, who officiated and signed the certificate, publicly confirmed that this was the sole legally binding ceremony. Any earlier private exchange of vows did not constitute a marriage under Church of England rules, which require witnesses and a licensed venue. Welby stated that signing a false certificate would have been a serious criminal offense, which he did not commit. The Church had already addressed Meghan's prior divorce in the ordinary way. No formal annulment proceedings have been initiated, and the marriage continues to be recognized. Justin Welby later resigned, in late 2024, over safeguarding shortcomings unrelated to the Sussex wedding. Sarah Mullally was subsequently named the first woman to hold the office of Archbishop of Canterbury. As of August 2026, the Duke and Duchess of Sussex retain their titles. Removal of a dukedom would require an Act of Parliament, and their children remain in the line of succession. Recent reports indicate the family plans to return to Britain, settling privately outside London with the children enrolled in school, while remaining non-working members of the royal family. Public impatience with institutional silence on various Sussex-related controversies is real, and comparisons are sometimes drawn with the stricter enforcement of declaration rules against ordinary citizens. Critics argue that prolonged inaction risks the perception that the palace and Lambeth Palace priorities institutional image over consistent application of the law, an especially sensitive matter at a time of wider erosion of trust in public institutions. Whether any formal challenge to the 2018 marriage ever materializes, it would represent an extraordinary constitutional and ecclesiastical event, generating intense scrutiny of the Church of England, the royal household, and the legal framework governing royal unions. For the present, however, the marriage stands as valid, the titles endure, and the succession order is unchanged. The question that has hovered in the background since the elaborate ceremony at Windsor in May 2018 is whether the public narrative of a seamless royal fairy tale fully matched the underlying legal and institutional realities. Some observers continue to ask whether the union rested on thorough process or whether institutional haste and incomplete scrutiny created vulnerabilities. The answer, as always, ultimately rests in the official records. For years, the dominant story presented a mid-level American actress rapidly absorbed into Britain's oldest constitutional hierarchy, transforming a prince's life and modernizing tradition. Behind the carefully managed imagery, designer appearances, and high-profile interviews, however, quieter discussions among some constitutional and ecclesiastical commentators have focused on whether standard safeguards were adequately applied. In ordinary UK marriages, applicants must supply original birth documentation, confirm residency, and make sworn declarations under threat of perjury. Foreign nationals face additional checks. Historically, anyone marrying into the line of succession underwent extensive background review by security services and crown solicitors covering family ties, prior legal matters, and financial history. Measures framed as necessary for national security and institutional continuity. Critics of the 2018 process argue that these customary steps were relaxed or accelerated amid a desire to avoid appearing obstructive or outdated in the international media. A rapid courtship, they contend, led the palace to accept certain accounts at face value and proceed without the full forensic examination previously applied. Central to these claims is the allegation that details entered on the official marriage register, particularly regarding the bride's date of birth, contained material inaccuracies. In entertainment circles, modest adjustments to age have sometimes been treated as commonplace. Under English law, however, deliberately false entries on a statutory register can engage the Perjury Act 1911 and the Marriage Act 1949. Proponents of the stricter view argue that a marriage license is a formal contract with the Crown, if the identity recorded does not correspond precisely to the person at the altar. The consent may be treated as defective and the union void from the outset under ecclesiastical principles of identity and truth. The then Archbishop of Canterbury, Justin Welby, who officiated and signed the certificate, has been placed at the center of these retrospective critiques. He later confirmed that the sole legally binding ceremony occurred on May 19, 2018 at St. George's Chapel, and that any earlier private exchange of vows did not constitute a marriage under church rules requiring witnesses and a licensed venue. Signing a knowingly false certificate, he stated, would have been a serious criminal offense, which he did not commit. The church had already addressed Meghan Markle's prior divorce in the ordinary manner. In the years since, no formal annulment application or official investigation into the certificate's validity has been initiated by ecclesiastical or civil authorities. Public records, including the California Birth Index and UK Companies House filings, consistently list Meghan's date of birth as August 4, 1981, matching the details used in official contexts. Claims of systematic age falsification have not been substantiated by primary documentation. Justin Welby resigned as Archbishop in January 2025 following an independent review of the church's handling of historical abuse allegations unrelated to the Sussex wedding. He was succeeded by Dame Sarah Mullally, the first woman to hold the office, whose election was confirmed in January 2026 and who was formally installed in March 2026. As of August 2026, the marriage remains legally recognized. The Duke and Duchess of Sussex continue to hold their titles, and their children remain in the line of succession. Recent reporting indicates the family intends to return to Britain to live privately outside London. Whether the discrepancies alleged by some commentators ever warranted formal examination is a matter of ongoing public debate. The official paperwork and subsequent institutional record, however, have so far upheld the validity of the 2018 union. In full liturgical vestments inside St. George's Chapel, the then Archbishop of Canterbury, Justin Welby, formally asked the congregation whether anyone knew of any lawful impediment to the marriage. He signed the register, affixed the ecclesiastical seal, and thereby endorsed the union as valid under church and state law. Welby's public standing was later tested when Meghan Markle stated in her interview with Oprah Winfrey that the Archbishop had privately married the couple in a backyard ceremony days earlier. Welby was obliged to issue a clear correction, affirming that the only legally binding service was the Saturday ceremony of May 19, 2018, and that any earlier private exchange of vows did not constitute a marriage under Church of England rules requiring witnesses and a licensed venue. He emphasized that signing a knowingly false certificate would have been a serious criminal offense. Subsequent commentary in certain legal and ecclesiastical circles has suggested that advisors later came to view even the public ceremony as potentially compromised by alleged inaccuracies in the details supplied for the marriage register, particularly claims of a falsified date of birth. The Church of England is not merely a religious body, it is the established church of the realm, with bishops sitting in the House of Lords and its canons carrying the force of law. Critics argue that allowing a possibly defective certificate to remain unchallenged in the National Archives would constitute a failure of both constitutional and pastoral responsibility. They contend that an ordinary priest who presided over a wedding in which a party knowingly misstated age or identity on the state register would face immediate nullification proceedings, and ask why a different standard should apply simply because the parties held high public profiles. If such an annulment were ever granted, the practical consequences would be profound. The title of Duchess of Sussex, conferred by Queen Elizabeth II upon a valid marriage, would cease to exist. The woman concerned would no longer be a former royal, but a participant in a ceremony later deemed to have had no legal force. The constitutional position of Archie and Lilibet Mountbatten-Windsor would also come under review, because succession rules are framed around lawful wedlock. Crown law officers would be required to examine eligibility under the Succession to the Crown Act. For Prince Harry, the personal impact is portrayed as especially severe, having relinquished military roles, criticized his family and commercialized aspects of his royal past in defense of the marriage. he would face the possibility that the legal foundation of that union had never existed. Buckingham Palace's continued silence is attributed by these commentators to reluctance to admit earlier institutional shortcomings in vetting. A formal recognition of invalidity would, on this view, confirm that standard background checks had been relaxed under media pressure. Ordinary citizens across the United Kingdom and Commonwealth who observe marriage and registration rules strictly are said to grow increasingly impatient with any perception that different standards apply to high-profile individuals. In historical fact, no formal appeal for annulment has been lodged. Official records, including the California Birth Index and UK Companies House filings, consistently record Meghan Markle's date of birth as August 4, 1981. Claims of systematic falsification have not been substantiated by primary evidence. Justin Welby resigned as Archbishop in January 2025 following an independent review of the church's handling of historical abuse allegations unconnected with the Sussex wedding. He was succeeded by Dame Sarah Mullally, the first woman to hold the office, whose election was confirmed in January 2026 and who was formally installed in March 2026. As of August 2026, the marriage remains legally recognized. The Duke and Duchess of Sussex retain their titles, their children remain in the line of succession, and the family is reported to be preparing a return to private life in Britain. The official paperwork and subsequent institutional record continue to uphold the validity of the 2018 union. The legal and documentary record is said by some observers to be steadily narrowing the options available to the Archbishop of Canterbury. Statutory requirements are unambiguous, and critics argue that the Church's room for maneuver on this question is diminishing. In their view, the episode was never primarily about modernizing the monarchy. It was about an institution that, under intense media pressure, temporarily relaxed the safeguards designed to protect it. Confronted by an individual they portray as treating the rules of the British state as optional, the palace is accused of having prioritized short-term public relations over long-term institutional caution. Ancient structures, these commentators note, have a tendency to outlast contemporary assumptions of exceptionalism. When the legal foundation of a marriage is alleged to rest on incomplete or inaccurate information, they warn that the consequences eventually surface. The core claim advanced in these circles is that the 2018 union is fundamentally void because of systemic shortcomings in pre-wedding scrutiny and an alleged material misrepresentation on the official marriage certificate concerning the bride's age. This is framed not as an ordinary divorce or commercial separation, but as nullity, a legal finding that the marriage between Henry Charles Albert David Mountbatten Windsor and Rachel Meghan Markle never lawfully existed. Supporters of this position contrast Hollywood practice, where modest adjustments to age have sometimes been treated as routine career management, with the stricter demands of English law. Under the Marriage Act 1949 and the Perjury Act 1911, entries in a marriage register must be accurate and verifiable. A deliberate falsehood introduced into an official Crown document, they argue, taints the contract at its root and may render it voidable or void from the outset. For years, certain genealogical researchers and legal commentators have pointed to what they describe as chronological inconsistencies in public biographical material relating to Meghan Markle, school records, early professional registrations, and past interviews. While these voices raised questions, the royal household is accused of having displayed willful blindness. How, the critics ask, did an apparatus renowned for rigorous security allow someone whose background had not been subjected to the fullest customary examination to proceed to a royal chapel? The explanation commonly offered is institutional caution amounting to paralysis. In 2017 to 18 palace officials, anxious to avoid accusations of reactionary or exclusionary attitudes, are said to have diluted or accelerated standard background checks that would normally apply to anyone marrying into the line of succession. The desire for progressive headlines and a contemporary public image, on this account, led to the bypassing of elementary due diligence steps, certified long-form birth documentation, thorough cross-referencing of American legal records, and verification that public biographical claims aligned with civil registers. In documented fact, no formal proceedings for annulment have been commenced. Official records, including the California Birth Index and United Kingdom Companies House filings, consistently record Meghan Markle's date of birth as August 4, 1981. Claims of systematic age falsification have not been supported by primary evidence. The then Archbishop of Canterbury, Justin Welby, who conducted the ceremony and signed the register, publicly confirmed that the sole legally binding wedding took place on May 19, 2018 at St. George's Chapel, and that any earlier private exchange of vows did not constitute a marriage under church rules. Welby resigned in January 2025 following an independent review of the church's handling of historical abuse allegations unconnected with his Sussex wedding. He was succeeded by Dame Sarah Mullally, the first woman to hold the office, whose election was confirmed in January 2026 and who was formally installed in March 2026. As of August 2026, the marriage remains legally recognized. The Duke and Duchess of Sussex retain their titles, their children remain in the line of succession, and the family is reported to be preparing a private return to Britain. The official paperwork and subsequent institutional record continue to affirm the validity of the 2018 union. The official paperwork was processed in the hope that the momentum of the public spectacle would carry the arrangements through. Critics now describe that decision as an act of serious institutional negligence, for which the consequences are said to be arriving. At the center of the resulting controversy sits Justin Welby, then Archbishop of Canterbury. Over several years he sought to manage the Sussex situation only to find himself repeatedly drawn into public difficulty by the same individuals. When Meghan Markle told Oprah Winfrey that the Archbishop had privately married the couple in a backyard days before the televised event, Welby was obliged to issue a public clarification. The sole legally binding ceremony was the service at St. George's Chapel on May 19, 2018, and he had signed the certificate himself. The irony, according to subsequent commentary, is that the Archbishop had staked his ecclesiastical authority on the validity of that Windsor ceremony, only for later claims to emerge that the document he endorsed may have contained material inaccuracies. As Primate of all England, the Archbishop is not a ceremonial figure. He is the senior ecclesiastical officer responsible for the administration of Christian marriage within the established Church of England, an authority governed by both canon law and parliamentary statute. If a formal appeal were placed before the ecclesiastical courts demonstrating that the marriage had been registered under fraudulent particulars, the officeholder could not simply disregard it. Leaving a potentially void marriage on the official register would, in this view, undermine the Church's legal integrity and its constitutional relationship with the Crown, while appearing to apply a different standard from that expected of ordinary citizens. The commercial implications of any such declaration of nullity are portrayed as severe. The title Duchess of Sussex forms the foundation of Meghan Markle's public and commercial identity. Peerage titles derived from marriage do not survive a finding that the underlying union never existed in law. Without a valid marriage, there would have been no Duchess of Sussex. The individual concerned would have participated in a ceremony later judged to have had no legal force. Corporate contracts negotiated on the premise of royal status would face scrutiny, and media agreements predicated on that prestige would become subject to review. For Prince Harry, the personal consequences are described as especially stark. Having severed close family relationships, published a detailed memoir of private pain, and relinquished official roles in defense of the marriage, he would confront the possibility that the legal foundation of the union he had defended had never existed. The psychological impact of discovering that the entire undertaking rested on a contract the state might not recognize is characterized as profound humiliation. Questions would also arise concerning the children. Under British constitutional and peerage rules, legitimacy and places in the line of succession are tied to the legal status of the parents' marriage. An annulment would require Crown Law officers and the Privy Council to address unprecedented issues regarding Archie and Lilibet's standing. The constitutional complexity of such a scenario is cited as one reason the palace has preferred silence, treating the matter as background noise rather than a formal legal question lodged in the National Archives. In documented fact, no formal appeal for annulment has been initiated. Official records, including the California Birth Index and United Kingdom Companies House filings, consistently list Meghan Markle's date of birth as August 4, 1981. Claims of systematic falsification remain unsubstantiated by primary evidence. Justin Welby confirmed the legal validity of the May 19, 2018 ceremony and later resigned as Archbishop in January 2025 following an independent review of the church's handling of historical abuse allegations unconnected with the Sussex wedding. He was succeeded by Dame Sarah Mullally, the first woman to hold the office, whose election was confirmed in January 2026 and who was formally installed in March 2026. As of August 2026, the marriage continues to be recognized in law. The Duke and Duchess of Sussex retain their titles, their children remain in the line of succession, and the family is reported to be preparing a private return to Britain. The official record continues to affirm the validity of the 2018 union. Public frustration across Britain and the Commonwealth is described as growing sharper over what many see as inconsistent application of the rules. Critics argue that an ordinary citizen who entered false particulars on a marriage certificate would face investigation and likely nullification of the union. They ask why a different standard should apply simply because the individual in question wore a high-profile wedding dress and married a member of the royal family. The rule of law, on this view, exists precisely to ensure that fame, wealth, or professional public relations support do not place anyone above the basic statutory requirements of the state. These commentators claim the walls are now closing in on what they characterize as an elaborate performance. The alleged shortcomings in pre-wedding scrutiny have been highlighted. Documentary material is said to be circulating among legal specialists, and the Archbishop of Canterbury is portrayed as facing a binary choice. Defend a potentially compromised document for the sake of institutional face-saving, or uphold the law and permit an annulment process to proceed. In this narrative, the fairy tale framing is finished, the televised spectacle is over, and only the unyielding requirements of British law remain. History, they note, shows that once the legal system begins to act, carefully constructed public images rarely survive intact. The central question posed is whether the episode represented a sophisticated deception practiced on a vulnerable royal household or the most serious administrative lapse in recent British institutional history. In the records of the General Register Office and the Ecclesiastical Archives at Lambeth Palace, these voices argue, sits an unresolved legal issue that has remained largely undisturbed since the spring of 2018. For years, the official presentation was of a modern diplomatic triumph that blended American celebrity with British tradition. Behind the ceremonial polish, however, legal scholars are now said to identify an irredeemable nullity, not ordinary marital discord or public disagreements monetized on television, but a fundamental failure of vetting that allowed a legal fiction to enter the constitutional records of the United Kingdom. At the center of this claimed crisis sits the then Archbishop of Canterbury, Justin Welby, facing what is described as an unprecedented need to consider a formal petition for annulment of the marriage between Prince Harry and Meghan Markle. To grasp the seriousness of the allegation, one must recall the strict character of British statutory law governing marriage. In parts of American entertainment culture, personal identity is often treated as flexible. Names change, appearances are adjusted, and ages may be revised for professional advantage with little consequence. When an individual whose career was shaped by that environment enters the rigid framework of the British state, different rules apply. A royal marriage is not a private domestic arrangement. It is a constitutional act that affects succession, peerage, and state privileges. Standard procedure in earlier generations involved exhaustive background examination, consultation with intelligence services, verification of birth registers, tracing of financial and marital records, because the stakes were institutional rather than personal. Critics contend that when Meghan Markle entered the royal orbit, these customary safeguards were not merely inadequate, but actively dismantled. Senior advisors, they argue, paralyzed by fear of being labeled intolerant or outdated, chose public relations optics over rigorous due diligence. The relationship was accelerated, security protocols were relaxed, and an unvetted foreign national was treated as an open book because challenging the presented narrative was judged too costly to the palace's media strategy. Courtiers are said to have accepted statements at face value, thereby enabling the subsequent difficulties. In documented fact, no formal annulment petition has been lodged and no official investigation into the validity of the 2018 marriage certificate has been opened. Official records, including the California Birth Index and United Kingdom Companies House filings, consistently list Meghan Markle's date of birth as August 4, 1981. Claims of systematic age falsification remain unsupported by primary evidence. Justin Welby, who conducted the ceremony and signed the register, publicly confirmed that the sole legally binding wedding took place on May 19, 2018 at St. George's Chapel. He later resigned as Archbishop in January 2025 following an independent review of the Church of England's handling of historical abuse allegations unconnected with the Sussex wedding. He was succeeded by Dame Sarah Mullally, the first woman to hold the office, whose election was confirmed in January 2026 and who was formally installed in March 2026. As of August 2026, the marriage continues to be recognized in law. The Duke and Duchess of Sussex retain their titles, their children remain in the line of succession, and the family is reported to be preparing a private return to Britain. The official record continues to affirm the validity of the 2018 union. Under the Marriage Act 1949 and the Perjury Act 1911, the particulars entered in a British marriage register are binding statutory declarations made under legal penalty. Supplying false, misleading, or fabricated vital statistics, including an incorrect date of birth, is a criminal offense. For years, certain genealogical researchers, independent biographers, and legal observers have claimed that the official timeline of Meghan Markle's biography contains irreconcilable inconsistencies. They point to early education records in Los Angeles, union registrations, and archived interviews as evidence that the stated date of birth, August 4, 1981, does not align with other historical material. In ordinary legal practice, they argue, a state register signed with false vital statistics is corrupted. If the legal identity recorded on the certificate does not correspond to the person standing at the altar, the contract suffers from an impediment of fraud and may be treated as voidable or, under strict canonical interpretation, void from the outset. This alleged defect is said to place the Archbishop of Canterbury in an acute difficulty. The holder of that office is not merely a preacher, but the primate of all England, a privy councillor, and the spiritual head of an established national church bound by parliamentary statute. When Justin Welby stood at the altar of St. George's Chapel and asked whether anyone knew of a lawful impediment, he was acting as a state officer executing a formal legal instrument. His earlier public dealings with the couple already involved controversy, when Meghan Markle told Oprah Winfrey that the Archbishop had privately married them in a backyard 3 days before the televised service. The statement effectively implied that he had conducted an unauthorized ceremony in breach of British marriage law. Welby was obliged to issue a clarifying statement confirming that the sole legally binding marriage took place on the Saturday. Commentators now claim that the same Saturday ceremony Welby publicly defended is itself open to challenge on the ground of defective particulars. If the Archbishop had knowingly presided over a marriage in which the bride submitted fraudulent vital statistics, they argue, his position would become untenable. The Church of England cannot retain its authority to conduct state marriages if its senior prelate is seen to endorse documents containing deliberate falsehoods. For this reason, an appeal for annulment is said to be under quiet discussion among ecclesiastical lawyers. An annulment differs from divorce. The latter recognizes that a lawful marriage existed and has ended. The former is a formal declaration that the legal requirements were never met and that, in the eyes of both church and state, the union never existed. The practical consequences of such a declaration are portrayed as extensive. The title of Duchess of Sussex, granted upon marriage, would cease to exist rather than merely be suspended. Peerage titles derived from marriage are legally dependent on the validity of that marriage. Without a valid union, Meghan Markle would never have been Duchess of Sussex. The title would revert to the crown and the commercial identity built upon it would lose its legal foundation. Business contracts, lifestyle partnerships, and corporate agreements negotiated on the strength of royal styling would face immediate legal review. A further constitutional difficulty would arise concerning succession. The Succession to the Crown Act ties hereditary rights, princely titles, and places in the line of succession to birth within a lawful, legally recognized marriage. If the parents' marriage were declared void, the standing of Archie and Lilibet Mountbatten-Windsor would become a matter of high constitutional urgency, requiring the Crown's law officers and the Privy Council to determine whether they could remain in the line of succession. In documented fact, no formal petition for annulment has been presented and no official investigation into the accuracy of the 2018 marriage certificate has been opened. Official records, including the California Birth Index and United Kingdom Companies House filings, consistently list Meghan Markle's date of birth as August 4, 1981. Claims of a different timeline remain unsubstantiated by primary evidence. Justin Welby confirmed the legal validity of the May 19, 2018 ceremony and later resigned as Archbishop in January 2025 following an independent review of the church's handling of historical abuse allegations unrelated to the Sussex wedding. He was succeeded by Dame Sarah Mullally, the first woman to hold the office, whose election was confirmed in January 2026 and who was formally installed in March 2026. As of August 2026, the marriage continues to be recognized in law. The Duke and Duchess of Sussex retain their titles, their children remain in the line of succession, and the family is reported to be preparing a private return to Britain. The official record continues to affirm the validity of the 2018 union. There is a deep and painful irony in the path taken by the Duke of Sussex. Here is a man who relinquished close family relationships, military affiliations, his homeland, and his position as a senior working royal in what he presented as an effort to protect his wife and uphold a shared narrative. He publicly criticized his brother, spoke critically of his father, and described the British establishment as cold and unkind, believing he was surrendering his birthright for the sake of genuine partnership. To learn that the person for whom he made these sacrifices had not supplied fully accurate particulars on the legal document that formalized their union would, according to this line of argument, amount to profound personal devastation. Harry would not simply be estranged from his family. He would stand revealed as the principal figure in a legal arrangement later judged defective, left in California amid the remnants of a life dismantled for a marriage the law might not recognize. The prolonged silence of the palace is explained by these commentators as an understandable reluctance to confront an indictment of the household's own competence. To acknowledge that the marriage was void would be to concede that courtiers, security services, and senior leadership had failed to conduct the most elementary background verification of a woman marrying a senior member of the line of succession. It would expose a preference for public relations considerations over rigorous constitutional safeguards. For years, the institutional hope appears to have been that the issue would recede into the background of American celebrity culture. Instead, the Sussexes maintained a high media profile and continued to invoke their royal association while criticizing the institution that had conferred it. Public patience across the United Kingdom and the Commonwealth is described as exhausted. Ordinary citizens who must produce verified documents for mortgages, passports, or civil marriages ask why an American actress appeared to operate under a different set of rules. In documented fact, no formal declaration of nullity has been sought or granted. Official records consistently list Meghan Markle's date of birth as August 4, 1981, and claims of material falsification on the 2018 marriage certificate remain unsupported by primary evidence. Justin Welby, who conducted the ceremony, confirmed its legal validity and later resigned as Archbishop of Canterbury in January 2025 over an unrelated safeguarding matter. He was succeeded by Dame Sarah Mullally, the first woman to hold the office, installed in March 2026. As of August 2026, the marriage remains legally recognized. The Duke and Duchess of Sussex continue to hold their titles, their children remain in the line of succession, and the family is reported to be preparing a private return to Britain. The official record continues to affirm the validity of the 2018 union.